Chief Hicks, I want to direct this to you because you have made very clear that on behalf of the Eastern Band, that you think that the Lumbee should go through the Office of Federal Acknowledgement, through the administrative process, rather than come through recognition through Congress. Maybe it is accurate that the administrative route is perhaps more costly, harder to do, subjective. Maybe we need to look at that in terms of whether greater oversight is needed there. But as Senator Mullen has indicated, there are two tracks, two routes that you can proceed for recognition. I almost find it curious that federal recognition is ultimately about a political relationship between a sovereign tribe and a federal government. So it just seems somewhat curious that we actually set up a process where that decision can be delegated entirely to an administrative state. But I'm not going to ask you to resolve that question for me. What I want to turn to is your written testimony. You claim that the Lumbee situation is uniquely beyond Congress's capacity to understand and evaluate. Can you explain why you feel it is unique in some way, separate from other tribes that have gained recognition through Congress? Because again, we have this process. It has been repeatedly exercised in terms of its constitutional authority to gain tribes. So if you can cite to what you feel are some of the unique aspects as to why Congress should not be the avenue here.
Thank you, Chair Lady, for that question. I think, if you look at the gaps that have been clearly identified by historians, by researchers, related to the history, these are aspects that I feel need expertise. They need genealogists. They need historians that do this on a daily basis. And, unfortunately, congressional staff don't always have that expertise to really dig into, the subject matter documents or the church records or, court records, things of that nature to really relate back to what is necessary as we feel to prove what you're saying is substantiation. And so, again, I think as you look at, that setup and that structure, OFA is better suited to make these determinations.
How do you respond then to Ms. Locklear's statement that she made early on that given the number of congressional hearings here in the Senate, in the House, that this issue of federal recognition that Lumbee is seeking has not established quite a voluminous congressional record with which to be able to turn to?
I truly believe that, if the Lumbee group would go through the OFA process, they would get the answer that they're looking for, wherever that answer falls. And, as you think about, this issue is well over a century old, and it continues to come back to the same conclusion. There's too many gaps in the genealogies. There's too many gaps in the history. There's no treaty relationships. Lumbee does not have a sister tribe in Oklahoma. There's so many things here that need to be evaluated. That's the importance of why it needs to go through the OFA process.
So, Ms. Locklear, let me turn to you. You have testified that congressional recognition is needed to correct what you have termed an injustice. Beyond that, you've got some practical differences between recognition through Congress and recognition from the federal acknowledgement process. You've got the ability to take land into trust, particularly in the Carcieri world here. Can you speak to some of these practical differences between the legislative and administrative recognition, and whether you think those are drivers for this legislation?
Absolutely, they are. Let me summarize with just a few points. First of all, I think it's important to put this controversy in some general history. As the Special Indian Agent reported in 1915 in the O.M. McPherson report, there is a history of 300 years of hostility between the Cherokees to the west and the ancestors of the Lumbee people, including the Cherokee, the Hatteras, and related Siouan-speaking people. And we just have, I think it's important to understand that context. As to the other issues, so as a practical matter, because of that, only Congress can resolve it forever. We have been at this for more than 100 years now, and I guarantee you that were the tribe to go through the acknowledgement process and succeed, as I am confident we would, there would be a lawsuit filed by the Eastern Band of Cherokee to try to set that administrative agency decision aside. That would not resolve it. There's only one way to finally resolve it, and that's through a conclusive act of Congress that extends full benefits and services. As you also implied, there is a problem with the Carcieri issue, which relates to eligibility of newly recognized tribes to receive land in a trust and thereby be treated like all other federally recognized tribes. Because of that 2009 Supreme Court decision that we call Carcieri, the only way to resolve the eligibility of the Lumbee for that process is through an act of Congress. Only Congress can clearly indicate that it considers the 1934 date to be insignificant, and whatever may arise out of the Carcieri decision, notwithstanding those terms, the tribe is nonetheless eligible for the land in the trust process. And finally, if there is going to be a special addressing of the cost factor, we don't think it's necessary, which I'm happy to expand on, but only Congress can do that as well. Congress is the one who appropriates the money, and if there needs to be more money for the Lumbee services, Congress can do that. We think the existing processes for appropriations will protect the presently recognized tribes, both in BIA and IHS processes, provide that only through the appropriation of additional funding that pay for those services will the Lumbee members receive those services at the end of the day. So federally recognized tribes now are protected. That being the case, if they believe there should be an increase in federal funding for the IHS and the BIA, again, that's a political decision to be made by the Congress. So we think for all of those factors, one final one, if I may. Only one other time in history has the Congress put an Indian tribe in the same position that it put the Lumbee tribe in 1956, and that was with the Isleta del Sur Pueblo of Texas. Congress passed a statute in 1968 for that tribe, which was at the time federally recognized, which basically said, we transfer any responsibility we have for this tribe to the state of Texas, and we're going to impose termination language upon the tribe. And in the legislative history on that act in the Senate, it specifically says that 1968 act, which then referred to the natives as Tiwas of Texas, was modeled upon the 1956 Lumbee Act, the only other time Congress has done that. And Congress fixed that problem in 1987 by passing legislation to recognize fully the Isleta del Sur Pueblo of Texas. Now, if Congress does the same for us, there are no other tribes in that position, and that's what makes it fair and just, as well as the only appropriate and fully dispositive way to finally and conclusively resolve these issues.